Okay, please be seated. All right, council. Thank you for working with us in this challenging time. Today, we are having oral argument in McRae versus Hunter, which is our case number CV19-0445. Council standard practice, you each have 20 minutes. Appellant, if you want to save time for rebuttal, I'm told, oh, there's a clock right there. Please do so. Also, I think we're still taping these proceedings, so introduce yourself and your client when you begin. And with that, let's go.
Thank you, Your Honor. May it please the court, first of all, can you hear me okay?
Yes.
May it please the court, my name is Stanley David Murray. I'm the attorney for the appellant Todd McRae, who was the petitioner in the lower court proceedings. I would like to reserve 5 minutes of my time for rebuttal. I want to start off with the March 31st, 2017 order, which established joint legal decision-making for both parties, pursuant to the recommendations that were made by Dr. David Weinstock, who performed a comprehensive family evaluation back then. And the parties reached an agreement on joint legal decision-making pursuant to various requirements that had to be followed. One of those is that the parties get individual counseling, that joint legal decision-making would be with the provision that a parenting coordinator would resolve any disputes that the parties might have, that the parties were not to initiate any texting with the child while the child was with the other parent, but they would share medical information. And in regard to the medical needs of the child, they would use Desert Shores Pediatrics, with mom taking the child to the various appointments. Well, not long after that order was entered into, mom violated that order, thus requiring my client to file his petition for modification. She was not sharing medical information with dad, and the medical information she did provide was inaccurate. The child's immunizations were not up to date. The child was diagnosed as obese, but mother did not disclose that to father.
Counsel, what's our standard of review? What do you need to prove and we need to find in order to do what you want us to do? Is there any deference to the facts here? If so, how much?
Yes, Your Honor, it is an abuse of discretion standard of review. I concede that. But part of that abuse of discretion standard requires review of the record to determine if there's any evidence to support the trial court's ruling. The trial court's ruling was that the mother was more likely to listen to the child, and we submit there is no such evidence to support that.
Okay, so no evidence at all. Is the standard reasonable evidence? If there's reasonable evidence in the record, then we affirm?
Reasonable evidence?
To support
any evidence, Your Honor.
Any evidence. Okay, so it's an even lower hurdle. All right.
Sir, when we look at the factors, the statutory findings that the court made under 25-403, none of those support a ruling that mother was more likely to listen to the child. And in fact, it was
didn't the trial court, didn't the trial court find the email evidence from the father ignoring complaints by the child, or at least alleged complaints by the child, supported the finding that mother would be more likely to listen to the child?
Which emails was that, Your Honor? The emails that the mother sent?
Yes, and father's response to those emails.
Right. That was what the court found was a violation of sole legal decision-making authority, which isn't true under the
But the court relied upon those to find that the father was not going to listen, and impliedly find that the mother was more likely to listen.
No, because it had to deal with the interaction between the parents, not between the parent and the child. Father listened to the child and came to the HPB vaccination. Remember, she didn't want to get the vaccination because she was worried about mother's reaction. And so father didn't force the vaccination on the child. She let her decide when she told mother about it because she was worried about mother's reaction. So again, I don't see any evidence in there that the father was less likely to listen to the child. In fact, we have this proof that he did listen to the child and deferred to her concerns about mother's reaction. That's just one example. The other things that had happened was that the mom had used the OBGYN service called Mom Docs instead of taking the child to Desert Shores Pediatrics. Now, my opposing counsel said that because the child was now in junior high school, that she couldn't use Desert Shores, but there's nothing in the record to support that. In fact, there's nothing to suggest that mother had even advised father that she was going to take the child to the OBGYN versus using Desert Shores. So another example of her violation of the order. But when you go to the temporary orders hearing, you'll find that the judge agreed with my client that he should have sole legal decision making when it comes to the medical records, medical authorization. She found that the trial judge found that mom was not acting in the child's best interest, that mom was not credible and exaggerated the child's medical conditions, that mom was shutting dad out of medical decisions, and so father was granted sole legal decision-making authority as a result.
Sorry. Are you talking about the temporary order?
Yes, sir.
Okay, so
because of the allegations my client had made,
okay,
we had a hearing on
right.
temporary orders.
So what's more meaningful, a temporary order or an order issued after an evidentiary hearing?
Well, the temporary orders hearing was an evidentiary hearing. It was very detailed, and in fact, the parties agreed that the evidence submitted at the temporary orders hearing could also be used at the final trial. So at that temporary orders,
So, counsel, that means that at the final orders hearing, the court was considering all of the evidence at the temporary orders hearing as well as the subsequent evidence of the things that occurred between the time of the temporary orders and the final orders, right?
Yes, ma'am, that's my understanding.
Okay.
I wasn't trial counsel, by the way. Mr. Schloss was the trial counsel. But as I reviewed the record, the evidence that was submitted was so strongly against mother that father was given sole legal decision-making authority. Now, what does that mean? That means he has sole authority to decide medical issues.
On a temporary basis, right, counsel? Are you arguing that there's some sort of permanence that, or some equivalent of some estoppel or doctrine or presumption or anything that follows in the shadow of a temporary order?
No, I'm just arguing what changed. What caused the judge to change her mind? And if it was because father wasn't responding to mother's emails about the scheduling of doctor's appointments, that's not sufficient. That has nothing to do with the best interest of the child. That's simply a communications issue between the parents. And we argue my client did not need her input because he had sole legal decision-making at the time.
So is it your position that the ability of the parents to communicate, the ability, for example, of father to communicate with mother and to work with her is completely and wholly unrelated to the best interest of the child? I mean, if the court's finding is regarding whether or not which parent is more likely to listen to the child and which parent is more likely to work with the other parent as the child's best interest, isn't that type of communication crucial?
It would be if it was joint legal decision-making with final authority of one parent. But as this court noted, as Dr. Weinstock noted, the parties don't get along. They can't communicate. And it was in those findings that the parties cannot communicate that joint legal decision-making was not feasible. So yes, if it's sole legal decision-making, the communication between the parents really becomes irrelevant at that point when it comes to making medical decisions. My client did provide the information about the medical appointments as is required to do, but as far as input and communication between the parents goes, when you have sole legal decision-making, that's not as important or relevant to that issue. The other issue that we raised about the findings of the 403, they're neutral really as to both parties. We don't dispute most of those findings, including that the child was too young to exercise any sort of preference, which the court amended its findings. But the court did not pay attention to the relationship between the father's family and the child. The court did not consider the mother's numerous complaints to the Department of Child Services or Child Safety. Again, the statute requires convictions, but at the same time, the mental health issue played a role here too.
And counsel, I'm sorry to interrupt. I know it's kind of awkward with this setting, but is the position, your argument, that she didn't consider, and you said two things. One, the relationship with the family. Let's take that she didn't consider that because it's not she doesn't mention it in the final order, or what allows you, or how are you inside of Judge Bergen's head and able to tell us conclusively what she did and didn't consider?
Just based on the finding that's listed in her decision, she simply stated the child has a good relationship with mother's family. Jerry doesn't mention anything about father's family.
Okay, so it's that she doesn't. Okay, go ahead.
Lost my place, I'm sorry.
Oh, take your time.
Oh, another thing about the...
We appreciate you doing this.
Sorry. We were talking about the mental health issue. You remember that the parties were required to obtain individual counseling. And at the temporary orders hearing, the trial court admonished mother for not following through and deciding on their own that she didn't need to use the doctor that was appointed by the court, whom she had selected. So there was no consistent mental health training or therapy for mother that Dr. Weinstock was very concerned about. Now, he didn't say she had mental health issues, but he felt that if she received that counseling, that would help in the legal decision-making, the joint legal decision-making that he noted at that time. And the parenting coordinator also commented about that, too. So the court didn't make any findings about either party having any mental health issues, but that, again, is not supported by the record when you look at these recommendations made by Dr. Weinstock and the parenting coordinator. Now, as far as father was concerned, my opposing counsel made a big deal about his temper, and he acknowledged that he did have a temper issue, and he expressed to the court that he was working that out through his counseling. So the father's getting counseling to take care of his issues. The mother wasn't getting counseling to take care of hers. And again, there was no evidence that father and child did not get along well. Again, he deferred to her on whether she needed to get that vaccine right away until she was able to discuss it with the mother. And the problem what we had was the decision that mother was more likely to listen to the daughter as she got older strongly suggested gender bias. The court had previously commented that girls were probably more comfortable going with their mothers to OBGYN appointments, when in fact mother did not attend the OBGYN appointment. She stayed outside the room.
Can I ask you?
Yes, sir.
Can I ask you, how would that? How is that consistent with the temporary order, in which she, from what you had just said a few minutes ago, I guess recognized sole legal decision making in your client? Did that, like, the gender issue arise in the interim, or between?
That's what I was trying to figure out, Your Honor. That's why we don't have findings that support the reasoning for mother having that preference, other than the court's prior comments about girls being more comfortable with their mothers, and also the order that father had to get an OBGYN consult about the HPV vaccine. Mother was the one that was against it for personal reasons. If anybody should have been ordered to consult with the OBGYN about that vaccine, it should have been mother, because she didn't have any scientific or medical information to support her beliefs that the child did not need that vaccine. So, yes, it's a conclusion that we're making from the record that there was a gender bias here, because, again, there was no evidence to support the mother should have sole legal decision-making on all issues involving the child. The other issue we raised was the attorney's fees. Because of the numerous violations, we feel that mother had taken inconsistent and unreasonable positions, that the court should have awarded attorney's fees to my client. unless there's any other questions, I was going to reserve my time for rebuttal.
Well, thank you very much, Mr. Murray. Mr. Collier, is that right?
Yes, Your Honor.
Okay. I guess we're going to hold on. You ready? One second. Some technical difficulties. Okay, let's go. Mr. Collier, you can go.
Your thing is frozen on
Hello? Hello?
His system's frozen.
We can hear you.
Yeah, I think Judge Weinsweg's computer is frozen because that's why he can't hear.
Well, and his is the only mic on, so they can't hear us.
Okay, so have him exit out.
Once wife?
Yeah.
Exit. Up at the top.
Can you
Should I
hear me?
unmute my mic and tell them what's going on?
Yeah, go ahead.
Gentlemen, can you hear us? Now everybody's
I'm
disappeared.
not sure if you're trying to communicate with me, but I can't hear anything but some vibrations. I think it's going through multiple
Okay, now,
mics.
Can you hear us now?
Have him open it again?
No, I can't hear you at all.
Can you hear us now?
Yes, yeah, I can hear you loud and clear now. Thank you, Your Honor.
Okay. We're having a problem with Judge Weinsweg's laptop, so if you give us a second to reload it.
Just get
Oh, okay. Actually, you can proceed. Go ahead and begin. We'll start the clock now.
Thank you, Your Honors. May it please the court, my name is Timothy M. Collier. I am the attorney for Lisa Hunter-Staub, who's also over here to my left. You can't see on camera. She's the respondent in the underlying case and the appellee in this matter. Your Honors, the trial court was not shy about expressing its disappointment in the two choices or the difficulty it had before. It stated it both in the motion for temporary orders hearing and reiterated it in the legal decision-making order on page 5. The court wrestled with this decision as it can see seen through the transcripts, and the trial court took as much time as allowable to review that testimony, the voluminous documents in this case, before she made the decision. There was no doubt one of these parties was going to be very unhappy with the trial court's decision because it became clear through all these proceedings that only one resolution could be had, and that would be sole legal decision-making for either mother or father. In this case, father is the unhappy party, but that's not grounds for appeal. The standard here isn't an unhappiness with the decision, but whether the trial court abused its discretion or made clear error in law when applying the 403 and the 403.1 factors, because the evidence, as appellate would argue, does not support the trial court's findings.
Counsel, I agree with you on our standard of review, but it's not absolute. There has to be evidence in the record to support the trial court's findings. So could you tell us specifically with respect to the issues that were raised by appellant's counsel and the decision that the mother would be more likely to listen to the child? What evidence in the record supports that?
Sure, Your Honor. I think counsel for appellant raises three basically categories: the positive interactions with appellant's family, the allegations towards mother's mental illness, and then essentially 8 examples or 8 arguments where she's allegedly violated the court order. The evidence actually doesn't support that. Now, those were father's arguments at the lower court, which were somewhat rejected, if not all rejected, but those weren't the evidence that was actually submitted. The court heard those arguments, considered those arguments, and decided in the way that the lower court did. So, for example, the positive interactions with his family, that argument is not supported by the record. One of the things that the trial court did was carefully...
Counsel, I'm gonna let you get to all that, but the question I asked specifically, what evidence in the record supports the trial court's finding that mother would be more likely to listen to and accept the input of the child with respect to medical decisions?
I understand, Judge Morris. My apologies. I disagree that it is gender-based, and I will get to that later. What the record fully supports was not just through the emails, as Your Honors had questioned Mr. Murray on, but also in some of the child's own statements in the medical records. There's ample evidence of father's attitude, listening skills, anger management, And the child herself, and I can't recall specifically if it was in a medical record or in one of the DCS reports, but at some points during the course of her interactions, was afraid to discuss these types of issues out of fear of his reactions. And the court discussed those things, and I believe, and again, I can't get the mind of Judge Virgin either, but I believe that was evidence that supported that mother would be more likely to reasonably listen to the daughter and make those decisions. The other portion of her ruling specifically is that she was also, the lower court was fearful that father, simply out of spite, even if mother and minor child would agree, would oppose or not allow the decision to take course if he was granted sole legal decision making. And that was demonstrated oftentimes through the trial by his own interactions with the court and his own testimony, in which the court noted several times where he knows best, it's his decision. And it's essentially
Counsel, can you hear us?
I can, yeah, thank you, Your Honor.
All right, we're getting some weird distortion. And your last 10 seconds was kind of tough for us to interpret. If you could repeat that.
Sure, Your Honor. And please, if you can't hear me, interrupt again. But I was focusing on the second portion of the court's ruling, in which the court asked me about regarding whether or not mother would listen to the minor child more frequently and take her into consideration. The second part of the judge's qualification to that decision, if you will, was that there was a fear based on father's interactions with the child, previous decisions, and demeanor in the court, that he was argumentative, knew best, didn't take the advice of medical providers, and that's clear in the findings of fact as well that the court articulated. And it concluded the court to say that father, even if mother and daughter were a decision, he may just out of spite and oppose mother, which would be not in the best interest of the child. So I think that the evidence fully supports that, and none of it is gender-based. And let me just address that very quickly, Your Honors. Mr. Murray cites one area of the transcript where the court does say it seems reasonable or something to that effect that a minor child would be more likely to be comfortable to talk to those issues with her mother versus father. Don't quote me on that paraphrasing, but I want to point out that in that portion of the transcript, I myself was arguing that the joint legal decision-making order, which allowed mother to go ahead and take the minor child to female-related issue appointments, was the essence of the factor, I'll say, at least to that respect, and I was advocating in that sense that medical decision-making should be allowed to mother for purposes of the temporary order.
Counsel, I'm sorry. I just want to make sure, can Mr. Murray, are you able to hear?
Yes, sir. I'm fine.
Okay, good. All right. There's a little bit of distortion. We're able to interpret and make out what is being said, but we're getting a weird kind of almost feedback loop, and I'm not sure if it's something on our end. I just wanted to make sure that Mr. Murray could hear it.
Yeah, I'm fine. Thank you.
Okay.
I'll adjust my posture and try not to yell into the computer screen. This is my first time with this technology. But what I was stating is that the portion of the transcript that Mr. Murray cites as support for the supposed gender bias by the trial court is actually the trial court rejecting my argument that mother should have final say into the medical decisions of the minor child for the purposes of the temporary order. So that is just proof that the court did not make this decision whatsoever on any gender bias because they rejected my argument in that hearing. It was simply based on whether or not mother was more apt to listen to the child based on the overwhelming evidence of father's interaction, not just with medical professionals and daughter and mom, but just his stubbornness with the court as well, too. So let me back up to the first argument regarding positive interactions with the family, that it was not considered by the court. I disagree. Dr. Weinstock's report was a comprehensive evaluation, which included the interactions of both families and the minor child. The trial court, in the very first hearing, the return hearing, had already read that report, I believe, and took that into consideration consideration and referenced it throughout the 3 proceedings. Remember, Your Honors, it was a return hearing, a motion for temporary orders hearing, and then a full trial that led to this final order. The trial court, had reviewed Dr. Weinstock's report in full and comprehensively, knew it very well. And so to say that father's interactions with his family, or the minor child's interactions with the father's family was not considered would be completely contrary to the court's continual reference to Dr. Weinstock's report. As far as the mental
Counsel,
illness,
refresh my recollection. What was the conclusion of Dr. Weinstock's report?
well, there were several recommendations. It's a very lengthy report. Some of it was adopted in the 331 jointly 2017 joint legal decision-making order, but essentially there were decent interactions with both families by the minor child. I don't think there was anything significantly adverse with any interaction with any family by the minor child. So again, it was kind of one of those neutral factors, which this case really has a lot of. The mental illness, appellant's allegations, the court specifically stated that it lacked credibility, and I'll remind the court too that the evidence suggested, the court specifically ordered that mother's parenting time would not be conditioned upon any sort of further evaluation. Now, if I can quickly, in the next few minutes, just focus on some of the arguments or the allegations that appellant makes here, but also made at the trial court that were fully considered. And as they suggest, support not so legal decision making for mother, but for father. I believe there's 8 examples. I'll go through them very quickly. The first one is taking the child to the OBGYN for female issues when the court ordered required mother to use Desert Shore Pediatrics. This is part of the joint legal decision-making order in March of 2017. First of all, I'll say to all these allegations, there's never been a finding of contempt. There's not in the findings of facts. These are just simply father's arguments that are not actual evidence, but solely father's arguments. And that's why we spent a decent amount of time in the response showing that this court would actually have to reweigh that evidence, which is contrary to the supporting case law that we put in our response. But specifically, the order from March of 2017 says the child shall continue to have her pediatric care at Desert Shores, and that mother, separate sentence, shall take her child to yearly checkup every year and any appointments related to female issues. They're 2 separate issues. They're 2 separate orders, if you will. They're 2 separate sentences. Mother did comply with that order. All the pediatric care was continued to be done through Desert Shores Pediatrics, but she could also take any other issues, according to the court record, or order, of female-related issues to a separate issue. So the bottom line is taking the minor child to an OBGYN is not a violation of that order. There's
Mr. Collier.
Yes, sir.
Can you hear me, counsel?
I can.
Okay. Can you address your colleague's argument about the significance of the temporary order in connection with the ultimate order?
Oh, yes, Your Honor. Well, obviously, a temporary order is just to set the ground rules based on the evidence at a very quick evidentiary hearing. It's temporary in nature until more evidence, sometimes more evaluation, and more testimony can be heard, which, of course, did happen. As we insinuate and even articulate in the response, this was essentially a trial run for father. I mean, he was warned that the court would be very mindful of the decisions he made and how he handled sole legal decision-making. So one of the issues that came up quite often was some emails that the court cites in the order about how father doesn't require any input from mother about scheduling appointments. Well, father was admonished that using sole legal decision-making as a sword might be consequential and have the court switch that decision in the final orders, which the court finally did. And this is a good example because father even admitted he doesn't have sole legal decision as to schooling decisions, but does to medical. But he was using his medical sole legal decision-making to get into these other areas to gain control in which there was still joint legal decision making. That was part of the court's analysis, and in addition to what they put. So the temporary orders is just that, temporary. The court, based on more information and more interaction and father's practice between the time of the temporary orders and the final hearing, is what caused that change in order.
Counsel, can you list off for us some of the additional evidence that was provided at the evidentiary hearing above and beyond the temporary orders hearing that would justify the result?
Yeah, sure, Your Honor, and I'm working from the fly here just from memory. I was trial counsel at that record, but I think what we put in our responses, there was 9 separate doctor's appointments in that very short order period. There were a plethora of emails in which the court cites to 3, among others, as I quote that order, that were considered as evidence in support of the change of decision. And then I think it was quite honestly, and again, I'm not in Judge Bergen's in the lower court's mind, but just the interactions that she had with father in the courtroom, which right at the end of the motion for temporary orders and during the course of the final hearing, just to name a few. So there was significant additional evidence, if you will, in a pattern of practice that, if continued or tolerated, would probably have just gotten more egregious. Obviously, I speculate there a little bit, but I think you can glean that from the orders and the additional evidence that was provided. Your Honor, I want to get to the second allegation. I know I'm running out of time here, but failing to obtain individual counseling. Again, the trial court did admonish mother, and quite frankly myself, that it should have been informed better of the financial status of not being able to avoid the individual counselor, and the trial court was right to do so. But appellate takes this a step further and says that mother failed to obtain counseling altogether. That's just not the case. The record is clear that mother did seek counseling that she could afford. She informed the trial court of this counseling. The trial court wanted more information. Mother provided more of that information, and it wasn't mentioned until the LTM order that we're here about, which the trial court obviously took into consideration and said they would not contingent, or it would not contingent the parenting time on mother's continued evaluation. The point to all of these, Your Honor, and the point that I'm making to all of Your Honors, to all of these allegations, is that as it applies here, appellate's characterization of the evidence is not the evidence that was actually presented. It is just their argument. And so this court, again, would have to reweigh that evidence in order to confine itself to defendant's arguments, which this court cannot do. Again, another allegation, failing to pay her share of the parenting coordinator's fees, in part. That's important. That's defendant's argument. Again, mother couldn't afford the PC. It wasn't a violation of a court order, as the appellants allege. It simply was her inability to pay. And in part is important because the parenting coordinator specifically said she could no longer be helpful based on both parties' actions, and she had sanctioned both. So again, as it applies here, the appellant is asking you to reweigh that evidence in a way that favors him, which the trial court has already carefully considered. There are an additional 4 or 5, there's 8 of those allegations altogether, and for the sake of time, with 3 minutes being left, I just want to point out that, again, refusing to acknowledge that the child needed therapy is not actually what's in evidence. That is father's argument, and you would have to reweigh that evidence. And I'll point out to that effect that even in Dr. Weinstock's report, and I think even in the comment that the appellant relies on with the judge, it was not a general denial that therapy wouldn't be needed. It was a type of therapy. Mother is a faith-based person in Dr. Weinstock's report that's reiterated, so she wanted the therapy to coincide with that, so it wasn't a violation of the order. The same with the direct payments for child support that father alleges is a direct order. That, quite frankly, Your Honors, is still undecided and kind of a mess here. We're not sure if Canadian court or Arizona court has jurisdiction. We simply wanted, and she acted on advice of counsel in 2 countries, Canada and myself, to try to get those payments made through the clearinghouse. That's all that was. It wasn't a violation of court records. Failing to provide father medical information, or not listing him on the documents as a contact information is another mischaracterization.
Counsel, with respect to all these, all the violations or alleged violations were raised and considered by the trial court. Is that
Yes,
correct?
Your Honor. Absolutely.
And obviously, to the extent they were accurate or inaccurate, the trial court had the ability to determine how significant it found those things as a factual matter in reaching its conclusion.
Yes, absolutely, Your Honor. I've often said when I discuss this case with Staub that you could try this case before 10 judges and 5 of them would find for mother, 5 of them would find for father. But that doesn't mean any of them actually abused their discretion or that there was a clear error in law, which is the standard here. As Your Honors know, you can disagree with the lower court discretion or decision, but that doesn't mean the lower court abused the discretion or made a clear error.
As long as there's reasonable evidence to support the lower court's decision.
Absolutely, Your Honor,
Okay.
and we believe there is sufficient evidence. And
So-
the court.
I would urge you, you got your minute left, again, to, we get that some of the allegations are disputed. Focus one last time on what evidence supports the trial court's decision.
Sure, Your Honor, the appellant's interactions, the emails, his course of conduct between the motion for temporary orders and also the final hearing, the child's own statements through medical records and DCS and father's inability to kind of take her into consideration when making these. For example, in the HPAB decision, that wasn't because the child said, okay, I'm not sure if this is going to be good. As it states in the brief, the appellant knew that was going to happen the day before trial and it would make him look bad. That's why it wasn't done, not because of taking the child's needs into consideration. In the last 10 seconds, Your Honors, I just want to address attorney fees very quickly. Both sides were found to be unreasonable. There's no reason to reverse that decision. That's what the court had said. We all have to live with that. And thank you for your time, Your Honor, and making the accommodation for this technology.
Thank you.
Thank you, Mr. Collier, and I guess, Mr. Murray, you have rebuttal.
Thank you, Your Honor. Again, this is Stanley David Murray for the appellant Todd McRae. Can everybody hear me okay?
We heard you loud and clear, Mr. Murray.
Good. One of the responses that Mr. Collier gave to Judge Morse's question about the evidence that supports the trial court's finding that mother would more likely listen to the child, Mr. Collier cited to the child's statements in some of the medical records. We know from the Reed case and the Diezi case that the court has to makes findings on the factors under 403 of what it considered in reaching its decision on legal decision making. And the court said in regards to the child's statements that the child was too young to express any preference. So if the court really did consider the child's statements, it would have had to put that in its findings. It didn't do that. So the statements of the child had no bearing on the court's decision. The second point that Mr. Collier makes about father's family, again, if the court had considered father's family under 403, it's required to make a finding as to what the relationship was between father's family and the child. There was no finding made here, so despite what was said in Dr. Weinstock's report, which, by the way, wasn't unfavorable, the court did not express whether it had made any consideration of the child's relationship with the father's family. That should have been in its findings.
But you don't dispute that the evidence was described in Dr. Weinstock's report and the court did consider it, right?
We have to assume that the court considered the evidence, but again, under Reed and the Diezi cases, the court has to specify findings as to what it relied on in making its decision. And because there's no finding in that regard, the assumption is it wasn't considered.
Okay.
Our point. Finally, about the allegations that we made, if the court will review the record, you'll see that mother admitted most of these allegations. She admitted that she didn't get counseling as required. She admitted she didn't pay for the parenting coordinator. And she admitted she sent the child to the OBGYN without father's prior knowledge.
Mr. Murray, I understand your argument with respect to the evidence. For the life of me, though, I'm having trouble understanding the significance that you place upon the findings or the alleged violations of the prior orders. I mean, as I mentioned with your opposing counsel, the court knew all that, was the one who had made the orders, and presumably is in the best situation, best position to determine how important those violations were. Why are we going to second guess that part of the decision?
Well, Your Honor, because those orders were made in the best interest of the child. The parties agreed that the orders were in the best interest of the child. So by not following those orders, violating those orders, the mother is not acting in the child's best interest, would be our conclusion.
Okay, and therefore your argument would be that because there's indisputed, I guess, evidence or clear evidence that the mother violated the orders, and your argument being therefore wasn't acting in the child's best interest, that the court erred as a matter of law in determining, reaching an opposite conclusion ultimately with the final orders?
Well, it certainly abused its discretion, and it did not follow the law when it comes to the 403 findings. And again, there was no evidence to support the finding that mother would be more prone to listen to the child than father would. So there's no basis for giving mother sole legal decision-making authority.
Okay, thank you.
And I don't have anything else to add unless the court has any further questions. I appreciate your time in accommodating us in these situations, Your Honors.
I'm looking at Judge Perkins and Judge Weinzweig. We have no further questions. Thank you very much for your time, both of you. I'll speak because my microphone is the one that's on right now. We will take this matter under advisement and issue a written decision in due course. Thank you both.
Thank you.
Your Honor.